Hello and welcome to Global Intellectual Property Index webinar presented by Taylor Wessing. I would now like to introduce you to your first speaker for today. He is a partner in the Taylor Wessing London office, Mr. Roland Mallinson. Mr. Mallinson, you have the floor.
Thanks, Gerald. Hello. Yes, as Gerald says, my name is Roland Mallinson. I'm from Taylor Wessing in the London office. That's me there. Welcome to today's webinar. We'll be looking at the findings from Taylor Wessing's 4th Global Intellectual Property Index, which was published a month or so ago. Our first Global IP Index, or GIPI as we call them, was published in 2008. GIPI4 came out in 2009 and GIPI3 in 2011. All 4 can be downloaded from our website. For those of you who are new to Taylor Wessing or our webinars, again, welcome. We're a full-service international law firm, but a substantial part of our business and much of the firm's heritage is focused on intellectual property and technology law. Our footprint spans Northern, Central and Eastern Europe, the Middle East and Asia, with offices located as shown on the map. Today's webinar is given by 7 members of the 32-strong team of specialist IP and data protection lawyers that compiled, researched and wrote the report. I'm a partner in the Trademark, Copyright and Media Group in London and have been the team coordinator and editor for each of the 4 reports. Our team was drawn from across the 22 offices that we have in 13 countries, and I'm delighted to have with me today Paul England and Vin Bange, who are alongside me here in London, Thomas Patlock, who's joining us from Munich, and Martin Prohaska, Rainer Schultes and Andreas Schutz, who are joining us from Vienna. Links to our profiles and with each of our contact details are shown on the slides as we go through them. I'll first give some background to the Global IP Index, and then I'll give an overview of the GIPI4 results. Paul's going to talk about the patent results, Vin will cover data protection, I'll return to speak about trademarks, copyright and designs. We'll then look at things from a geographic perspective, with Martin, Rainer and Andreas focusing on Central and Eastern Europe, and Thomas then shining a spotlight on China. I'll come back to touch on a few more of the general themes coming out of the GIPI4 results. The presentation will last about 50 minutes, leaving about 10 minutes at the end for questions. Feel free to send us your questions as we go along, and we'll try to answer them, as many of them as we can. But we do have a lot of attendees today, connecting at the last count from 24 countries from around the world. Particular to thank you to those of you listening in the middle of your night. I know it requires concentration to do so. I've spent a number of nights in the past few weekends glued to the radio, only to hear of yet another thrashing from England by Australia in the cricket. So I hope your nighttime listening here is a little more enlightening and happy than mine was then. Anyway, it does mean we may struggle to answer all of your questions during the webinar. Just if so, we'll be happy to follow up with you individually afterwards. So, what is GIPI? I'll start by explaining what it is and how it's compiled. It's essentially a league table of the IP regimes of 36 jurisdictions around the world. It looks at the activities of obtaining, exploiting, enforcing and attacking each of the individual IP rights in those countries. The IP rights in question are patents, trademarks, copyright, designs and also data protection. Respondents to a survey chose which countries to reply about and which IP rights to do, and then they were scoring between 0 and 10 on a scale. They also had an opportunity to add comments and answer a few questions. The GIPI4 survey closed at the end of April 2013. Many of you listening today kindly took part in that, and thank you if you did. The raw results of the survey then go through a statistical process of weighting. This is for 2 reasons. The first is to add objectivity. We do this by weighting the results by reference to 74 sets of published and empirical data available on each country, some of which is IP specific and some not. They include the number of patents and trademarks filed, the value of local IP licenses, fees, and how often a country is found to be the source of counterfeit goods when seized by customs. The second reason is to remove any perception of bias. This is done by partially discounting a respondent's score if they were scoring their own country only and no others. Finally, the actual report writing takes into account our research for each IP right to identify new laws, any major cases, and any anticipated or likely reforms in each country. As a result, we believe the Global IP Index is the most objective assessment there exists of how one country's IP regime is faring compared to its peers. GIPI4 GIPI4 reviews 36 jurisdictions, 12 more than we looked at in GIPI3. Before looking at the GIPI4 results, it's worth looking at some context. One of the questions we asked was whether the respondents were spending more time or less time on IP issues than previously. So these are the results we got from that question. So we had 60% saying that they spent more time, which is about the same as the figure we got in GIPI2 and GIPI3. So companies are consistently increasing the time they invest in IP, which only happens if they see it as increasingly important to their business. At the same time, though, actually 51% of respondents told us they were spending the same or less money on IP issues. So with the majority spending more time, but not more money on IP, it seems in-house teams are managing to be more prudent and efficient with their IP budgets. Those in private practice may recognize this trend. So coming now to the overall rankings. Now, I appreciate this will be rather small and difficult for some of you to read. You can, if you wish, click on the full screen button in the bottom left-hand corner of your screen to make it bigger. But those are the results there. If you squint, you'll see. What you can also do is perhaps open a second screen on in your browser by going to the taylorwessing.com IP Index microsite, which also on there has a click. If you click on the map page there, you can then go through the results of individual countries. An example here is the US, and you can click on the US and then pick out each individual slide. You can pick out each individual trademark, patent, copyright score and get the more details there. So that's something that you might want to do now and have simultaneously running in a separate browser page. If we come back to the overall ranks and ratings then, it's worth pointing out, firstly, that the rating score is out of a maximum of 1,000. This means differences of less than 5 points equate to a variance of only 0.05%, which is pretty marginal statistically. So whilst the UK is placed in first place, that's only by 1 point. It's effectively on a par with Germany and the Netherlands, and Sweden and Australia are only a little bit behind. You'll see the second column shows a tier number. This ranks the jurisdictions on the basis of a statistical cluster. So to pick out a few, we've got Tier 1 containing 4 EU member states plus Australia. The USA sits in Tier 2. That's a fall, actually, from the GIPI3. And Indonesia, China, and India make up the bottom tier. So Brazil has now moved up into fourth tier. Other points arise from a comparison with GIPI3 are the biggest movers in real terms, ignoring the 12 new joiners, were New Zealand up 6 places and Mexico down 7 places. EU member states are scoring more closely together this time, despite the addition of 5 new EU member states to the index. I'll touch on that a bit later. The scores for countries in the top half of GIPI3 all fell between 41 and 95 points, or about 10%, whereas those ranked in the last 3 of the GIPI3 index all scored more highly, with India ranked bottom again here, almost having caught up with China, who is now second bottom. This means the spread of scores has once again narrowed, continuing a trend from GIPI1 onwards. The gap is now just under 100 points, whereas it was originally in GIPI1 over 300 points. The most dramatic changes have been falls for Australia, New Zealand and Singapore for data protection, and Vin will explain this later. This table shows the ranking for each IP right. For reasons Vin will explain later, the data protection rankings can effectively be considered in reverse order. Either the UK or Germany occupies the first or second place for each IP right. That can be seen here. And India occupies the last or second last place for each IP right. When compared with the third index, that's a step forward for the UK and Germany, but backwards for India. Data protection, Vin's going to touch on later. So, the key reasons for scoring highly, things I think we should pick up on this slide here. In the GIPI3 report, we concluded that costs, in particular cost effectiveness of enforcement, had been a key factor in influencing scores for each of the IP rights. In this index, costs are much less clearly as determinative. There were many less comments relating to costs. On the whole, the priorities for respondents now seem to be, firstly, speed of decisions. That's whether registry refusals or acceptances and judgments in the registry or court disputes. Particularly excessive delay was top of the list of complaints. Secondly, quality of decisions. meaning the consistency with international norms and therefore a reasonable degree of predictability. This is often addressed by having specialist IP courts. Paul's now going to look at some of the patent results.
Thank you, Roland. Now, the global survey this year reveals distinctive groupings for the established and developing economies in relation to patent matters. The top of the table is clearly dominated by Western European jurisdictions: Germany, the UK, the Netherlands, Sweden, Switzerland, and Austria. And I'll come back to these shortly. These European countries are followed closely by Australia and New Zealand. Australia is clearly a big economy in the Pacific region and well known for its patent sector, but New Zealand is much smaller. Nonetheless, both have higher scores than those received by their relative neighbours: Japan, which is a far larger economy, and South Korea, which is at least comparable to Australia in size. The US is in the next grouping, a third of the way down our rankings, together with Canada and Japan. This is perhaps a surprising position for three huge economies with highly established and important patent systems, and I shall be suggesting some clues to why this is from our survey's respondents' comments in just a moment. Finally, the so-called BRIC economies, together with Argentina, all appear in the bottom half of the table. Although I mention them together here, it should be noted that they all face quite different issues. It may also be too early to see the results of reforms that are taking place to keep pace with economic ambitions in some of these countries. For example, in Brazil, steps are being taken to halve the grant time of a patent. In Russia, duties for foreign patentees have been abolished recently, and a new appeal court for dealing with IP cases is being established. My colleague Thomas Patlock will talk about China in a little more detail shortly. So why do Canada and the US seem to underperform relative to their economic status? As regards the US, the sophistication of the system, or rather its complexity, may be one key to this. Complexity in legal matters results in high cost, particularly of fighting proceedings. This is undoubtedly a factor in the US, and I've highlighted a rather dramatic statement received from one respondent to our survey that encapsulates this. The burden of cost is too high, even if the case is won. Clearly, this represents a problem for small and medium-sized companies who can feel cost is a barrier to accessing justice in the US. Curiously, the subject of patent trolls, or patent assertion entities, is not mentioned in the global survey, although this is a dominating feature of the system at present in the US. However, other matters relating to software and business method patents, which are central to the IT and telecom sector in which patent trolls operate, are raised. Our respondents suggest that recent deliberations in the courts in the US on patentability, both the Prometheus ruling, are also a concern. In particular, the federal court decision in Alice Corp and CLS International has been widely criticised for failing to produce an objective, workable standard on software and business method claims, and seems to have triggered a very visible split in approach between judges at the federal court in a number of subsequent cases. This matter, incidentally, has now been appealed to the Supreme Court. So as regards Canada, the feedback is less specific, but a notable aspect is the assertion that it is too difficult to defend the validity of pharmaceutical patents compared to international standards. However, the IT and telecom sector has received a boost in Canada from the decision in Canada and Amazon, which states that the novel business method may be an essential element of a valid patent claim and approves guidance on the obtaining of patents on software and business methods. So turning to Europe, clearly the headline observation is that Germany and the UK dominate the table, but there are significant differences between their systems. Germany tends to be favoured by patentees for enforcement because of the split of infringement and validity trial systems. This usually allows a final injunction to be obtained before the validity of the patent being enforced can be tested. A powerful weapon for a patent owner in negotiating with third parties. In the UK, on the other hand, validity and infringement are heard together. However, the speed of first instance and appeal proceedings, which can be heard often inside 2 years, makes the UK a popular jurisdiction for seeking the revocation of patents perceived to have weak validity. And because they are typically detailed and reasoned, a decision in your favour in the UK can be a helpful one to have when litigating in the courts of other jurisdictions. However, the Netherlands also provides a clue as to why all three of the top jurisdictions in the index are where they are. As well as being very cost effective, the Dutch jurisdiction, like Germany and the UK, is well known for highly respected judges and practitioners who specialise in patent matters. In other words, there's trust in these courts to make considered and consistent decisions based on a thorough understanding of patent law and, in many cases, the technical subject matter at issue. And we mustn't forget the European Patent Office. This is not included in the main table because it is a pan-European body dealing with patent grant and opposition only. However, in these areas, it is the highest ranked body. And whilst this does not reflect the speed of its procedures every time, it is an endorsement of the level of expertise the office has in examination and in the opposition and appeal divisions. Now, the importance of cost effectiveness and judicial decision making of a high quality is a point made consistently by respondents to the index. And the success of the top European patent jurisdictions in this respect is particularly important given the advent of the Unified Patent Court and unitary patent, which may come into force as little as a couple of years from now. This is because whilst the UPC will bring a uniform set of new procedures, these procedures are based on those of the leading European jurisdictions. Furthermore, many of the practitioners who will be frequenting the court, and most importantly the judges making the decisions, will come from these countries. The EPO will also remain the body examining and granting unitary patents, and EPO oppositions will be available for opposing them, just as they are now, as well as the possibility of revocation in the UPC. The expertise of the EPO is therefore going to be retained and applied in the UPC. Another important point to note is that the branches of the UPC Central Division will be located in London, Paris and Munich, making the practitioners in those locations particularly convenient for clients. The index also reveals more food for thought on this subject. In particular, there have been suggestions from commentators that some local and regional divisions of the UPC, those located in countries outside the northwest of the continent, will suffer from a relative lack of experience in judicial decision-making on patents. However, the index indicates that Sweden, Austria, Hungary and the Czech Republic are also highly regarded jurisdictions, rated in our survey comparably with the US and Japan. This is important because judges from these countries will be members of what is called the pool of judges in the UPC, and will sit in the local and regional courts around Europe, as well as the Central Court and Court of Appeal, and that's shown by the pink characters in the figure on the picture you're looking at now. So the interesting message from the index as regards patents is therefore that ahead of its biggest challenge in 40 years, the European patent system looks in good health. With that, I will now pass my colleague, Vin Bange, who's going to discuss data protection.
Thank you, Paul. Hello, this is Vin Bange. I'm head of the data protection practice based here in London and responsible for the data protection aspects of the GIPI report. Information and personal data continues to be important to commerce. The value of data seems to increase in line with our technical ability to capture more data and process it faster, and also take it into new territories. Data is often seen as the core around increasing the ability to reach new customers. It's often seen as fundamental to increasing revenue from existing customers, and also towards achieving greater knowledge and insight for a business's own purposes, as well as intelligence for other players, the so-called promise of big data. So I'm pleased that we've included data protection again in this fourth report, given the impact that data have on commerce today. Unlike other mainstream aspects of IP considered in this report, data protection has a different approach, with fundamental considerations around, for example, the ability to collect data and the obligations that surround that, the rules around using that data, for example, for marketing purposes, the type of framework that applies, for example, data security frameworks and data export obligations, and also the compliance burden surrounding that data activity, as well as the attitude and activity of the local data protection regulator for that particular country. Therefore, compliance is about the applicable framework of data protection law. Enforcement, however, is not about enforcing the right to use data in the same way that you would view enforcement options around your IP. In this case, it's a negative position in data protection terms because enforcement is around non-compliance and therefore damaging and potentially reduces your ability to use personal data. As a result, as we mentioned before, the table for data protection actually works in reverse. The higher the rating means that there is little, no, or weak data protection law and a regime for that particular country. A lower rating, or if a country is lower down the table, suggests higher costs of compliance and a potentially harder regime in which to collect, use, and process data more freely and more commercially than would otherwise be desirable. The Data Protection Index shows that data protection compliance is shifting its focus away from Europe, where it's really been placed over the last 5, 10, 15, 20 years even, and it's shifting that focus towards Asia. So let's look at a few examples of the countries that are demonstrative of that particular shift. India moves up to the top of the table, reflecting the absence of any specific data protection law in that country. The Data Protection Bill from 2006 has made no real progress since our last report. Certain other measures are in place, including rights to compensation and some enforcement mechanisms around failing to secure IT practices and procedures. However, the position is summed up by one respondent who points out that the absence of business law restrictions and non-existent enforcement in the country is key to where India is placed as far as data protection compliance is concerned. Japan, the reason for Japan's shift down to 30th position is not immediately apparent, but may concern the controversy around the passage into law on the 24th of May 2013 of a national ID number system. The government in Japan is required by the new ID law to implement changes to the existing data protection regime. This could lead to wider reform of data protection law in Japan, a move that would be welcomed by one commentator who pointed out that the existing regime is more in favor of businesses than individuals. So perhaps Japan is an example of where uncertainty around data protection law change is a key factor as to where it's positioned at the moment. Singapore's dramatic drop in ranking to bottom of the table can be attributed to the approval on the 15th of October 2012 by Singapore's Parliament of the country's first full coverage data protection law. The law marks a clear departure from its previously more limited and sectoral approach to data protection and reflects the intention to position the country as a leading financial services and data hub in the whole Southeast region. The law came into force from January 2013, although a transition period of 18 months for the main provisions of the law means that businesses have until July 2014 to bring their processes and compliance into line with the new law. New Zealand's drastic change in position down to 34 could be due to the formal recognition by the European Commission of the adequacy of its personal data protection law, and this adequacy finding took place on the 19th of December 2012. This finding has the effect of removing legal restrictions on personal data transfers out of the European Economic Area to New Zealand. This EC recognition follows amendments made by New Zealand's Data Protection Law by way of Privacy Cross-Border Information Amendment Act 2010, which, among other things, introduced controls around exports of data outside of New Zealand and also extending the rights of access to all data subjects, rather than the previous position, which was data subject access requests only to New Zealand citizens. Australia has seen a big drop of 25 places in the table, and this reflects a number of enhancements made to its existing data protection legislative framework in recent years. Indeed, a new Data Protection Act will come into effect on March 2014 and will include new privacy principles. These will comprehensively extend the regime around the collection, use, disclosure and transfer of personal data. The law also introduces a new definition of personal data, which is more aligned to that more extensive definition that we have under European data protection law. So those were just a few examples focusing on that shift that we're seeing on the global data protection landscape from Europe towards Asia. And we covered the data protection aspects of the GIPI report in more detail in a dedicated webinar, and that broadcast took place in December 2013. That webinar was part of our data protection webinar program, and if you still want to tune into that, you can access that webinar recording via the Global Data Hub alongside more detailed written commentary on the data protection aspect. They're also accessible on the Global Data Hub, which is Taylor Wessing's microsite dedicated to all things data protection. And on that note, I'll hand back to Roland.
Thank you, Vin. So looking at the trademark index, like the patents index, it bears some resemblance to the overall rankings, meaning those in Tier 1 overall tend to score highly for trademarks and those in Tier 3 tend to be in the middle, and so on. There is some also correlation between cost effectiveness and the overall results, although by no means is it a straight line correlation. So we have Germany, New Zealand and the Netherlands topping the table for cost effectiveness, and the UAE, Saudi Arabia and China at the bottom, but not quite so clearly positioned the same way in the overall result. The US scores towards the bottom for cost effectiveness for trademarks, with some respondents complaining at the six-figure dollar cost of an appeal from a registry decision. That's likely to have been the cause for its 10th position overall here. In terms of the changes since the third index, those that have been at the top of the quarter of the table all saw their scores fall, but less than this time than had occurred between the second and third indices. The same countries, UK, Australia and Germany, take the top 3 positions, but their lead overall over the others has narrowed. The top 10 countries are also largely unchanged. Amongst them, however, New Zealand, previously 10th and now 4th, made a notably big improvement in its score. Poland also made notable gains, whereas Mexico and Russia saw material drops in score and position. Issues of delay and quality of decisions are as relevant to the trademark index as to the other indices. Very long delays in the Indian, Russian and South African trademark registries in particular were singled out as determinative of their poor scores. Ironically now, given the teething problems that we're currently having with its new website, OHIM won praise for its efficiency and good online services. However, appeals to the European Court were criticised as poor and unbalanced. Other factors particularly relevant to the trademark index included court-only cancellation actions. The cost for filing cancellation actions at registries where permitted, such as the UK IP Office and OHIM, are now fairly low, and decisions can follow in as little as 6 months. However, many countries require all cancellation actions to be filed at court. That route is invariably slower and more expensive. It's why Australia, Spain and France, amongst others, scored less well for attacking trademarks, although Switzerland managed to buck that trend. This may change soon for EU countries, at least, if the European Commission's proposed reforms to the Trademark Directive are implemented. These oblige member states to offer a registry cancellation option. That ought to improve the attacking trademark scores for the 11 EU countries that presently only allow the court route. The Australian government was the first to implement in 2012 a ban on the use of any logo or non-standard shape or colour on tobacco packaging. The law has been and is still being challenged by the tobacco industry and a number of tobacco-producing countries, but brand owners in other sectors are also concerned that this is a step closer to similar bans affecting their branded fizzy drinks and snack foods, again justified on public health grounds. In fact, plain packaging was not cited as a particular issue by respondents, but our survey closed only a few months after the Australian law took effect. Since such legislation is being contemplated by at least Ireland, Canada and the UK as well, we anticipate it having a more material impact in a future index. In certain Middle Eastern, Latin American and Asian countries, Bureaucracy is a major concern to many respondents. This particularly relates to the need for a power of attorney as proof of authority, especially if it's needed to be notarized and legalized, as in Argentina. A refusal to accept multi-class registrations will have brought the score down for Brazil, Mexico, South Africa, and the UAE. Japan is thought to have an inflexible approach to specification drafting, especially when we're dealing with new media services. And in Saudi Arabia and UAE, amongst other countries, the process can actually involve personal attendances at government offices, even for routine registry steps. These all add to a brand owner's costs and cause delay. Typically, it affects not just the obtaining trademark sub-index, but also the overall trademark score. Greater participation in the Trademark Law Treaty and membership of the World Trade Organization and Madrid system has already helped with this. They are largely the cause for the ever-narrowing range of scores between top and bottom in the trademark indices since GIPI4. Lastly, counterfeiting. A perception that counterfeiting is widespread in the country will reduce its score. This is certainly true of China, which Thomas will discuss later, but also of Indonesia. In contrast, Singapore has a good track record for tackling counterfeits and scores well for trademark enforcement. Looking at copyright, the index saw the UK and US again top the rankings, but this time with the UK marginally ahead. Significant risers in the index were South Korea and New Zealand, and there were material falls for Ireland, Australia, Mexico, and South Africa. It's worth picking out New Zealand for leading the way on its graduated 3 strikes and you're out internet user sanction. This has been introduced in France, but in a somewhat watered-down version, and the UK equivalent has been held up until 2015. The top third of the table all saw their scores drop, in many cases by 10% or so. In contrast, all countries in the bottom half of the table increased their scores, some quite significantly. For example, China's score went up almost 30%. The result is that the copyright index now has the lowest score for the top position and the narrowest range of scores between top and bottom, at just over 50 points. Within that range, the scores for the 13 EU countries in the index was even more narrow. On the whole, regimes favouring copyright holders over copyright users have been scored more highly in the index. On that basis, Japan might have expected a higher score, having passed law criminalizing the act of knowingly downloading from illegal file sharing sites. The lower scores at the top of the table seem to reflect a perception that recent reformers have favored copyright users too much, adding to the number and scope of defenses. The general idea behind relaxing enforcement is to promote creativity in the long run, but whether it has had that effect remains to be seen. We asked respondents whether IP rights were effectively fit for purpose in light of the advancing technology and modern internet uses. As you see, 68% said no. Respondents' replies focused almost entirely on copyright reform to address this. One singled out Israel's copyright law as being especially out of date, but a US official review also identified its laws as showing the strain of its age. This sentiment to modernize copyright, so it is fit for the digital age, is driving some major changes currently. More than half of the 36 countries in GIPI are either making or contemplating extensive changes. Legislators now seem to want to introduce wholesale reform to copyright laws rather than just make incremental improvements. This is the case in the USA, Australia, the UK, Ireland, Canada, Mexico, Slovakia, and Sweden. Pleasing everyone is always a challenge. And amongst their IP drafting colleagues, those writing our copyright laws face probably the hardest task in striking a fair and reasonable balance between the interests of users and owners of the IP right. Since the last index, there's been a perceptible shift in favour of the copyright users, at least amongst public opinion and lawmakers. In Canada, that shift has manifested itself in various new copyright offences being added to their laws, including an unusual one that specifically allows users to make non-commercial mashups of copyright-protected music. And also it's resulted in a spate of 5 Supreme Court decisions that have given notably liberal interpretations of Canada's fair use defences. Copyright is now probably the most politicised of the IP rights. We saw this in the Google and Wikipedia web blackouts in January 2012, which resulted in the SOPA and PIPA legislation being dropped in the US. Sadly and inexplicably, it's also led to the downfall of the Anti-Counterfeiting Trade Agreement, or ACTA. Ongoing friction between the two polarized sides in this debate is likely to have led to the lower copyright index scorings overall. Meanwhile, many countries have at least seen increasingly settled case law clarifying some of the key recent issues that have troubled lawmakers and the courts, namely on the three subjects you see on the slide: ISP hosting liability, injunctions against ISPs to block access to pirate sites, and the scope of the communication right. On that basis, the general position is that most countries are modernizing their copyright laws to suit the modern age, but there is a concern that they're not doing so sufficiently quickly or extensively. Now I turn to designs. From the GIPI4 results for designs, it seems respondents score more highly if they get more protection for their own designs and care less about having more design freedom to compete with third-party designs. That much is fairly evident, but invariably there is some limitation on how empirical we can be about designs, since there's no one clear definition of what design law is. The protection given for designs, if any at all, varies significantly from country to country. Some have sui generis design laws, others restrict protection only to what is registered, and the more generous provide unregistered design rights and copyright. There can even be perpetual protection if a two-dimensional design or a three-dimensional shape mark can be registered as a trademark. It also depends on what the design is for. Some jurisdictions will exclude protection for industrially exploited designs, and like in the US, will only permit registration for the ornamental or decorative aspects as design patents, with any functional aspect specifically excluded. Despite these difficulties, we feel it is still possible to make some comparisons. What is noticeable is that the overall design scores for all countries have fallen since GIPI3. This suggests respondents either have greater expectations of each country or are expressing greater frustrations with them. The comments of some respondents, not always entirely polite, indicate it's the latter. The so-called tablet wars between Apple and Samsung have certainly raised the profile of design law around the world. However, the conflicting decisions by numerous courts, at least in the UK, the Netherlands, Germany, and the USA, seem to have reduced people's confidence in the predictability of design law. More than for all other rights, Europe dominates the top third of the table. This isn't confined to the EU, since Switzerland is also highly ranked. Initially, to protect its major watch design industry, Switzerland has had design laws in place for more than 100 years. In contrast, Austria's design law dates to 1990. It's the European unregistered design right, which lasts 3 years and protects both functional and aesthetic designs, that is key to the EU countries topping the table. It's been a powerful weapon in sectors where designers are creating many new designs, often fairly short-lived, such that it may not be worth spending the money to register every design. Examples of this are fashion goods, decorative objects, and home accessories. The absence of design protection for fashion goods, in particular, is also a key reason for the USA's 17th position. One respondent's comment summed it up. The US does not protect design rights sufficiently. The current position is that the artistic aspects are considered inseparable from the functional ones, and so cannot be registered as design patents. This may soon change if the pending fashion bill is enacted. However, that alone may not salvage the US ranking, since it also came last for cost-effectiveness of design enforcement. Canada also saw a major fall in its score and ranking since GIPI3. This is less easy to explain, but it seems it was influenced by the high-profile designer case Bowden having a registration invalidated in the first trial for 20 years. China raises some more interesting issues relating to designs, but Thomas will be covering that shortly. Before he does, Martin will talk next to introduce the position on the CEE region.
Hello, this is Martin Prohaska from Taylor Wessing in Vienna. I may introduce my partners, Rainer Schultes of our CEE Patents Group and Andreas Schütz of our CEE Data Protection Group. We will now briefly present the GIPI rankings for CEE. As you can see on the slide here, the performances of the 4 neighboring countries, the Czech Republic, Hungary, Poland, and Slovakia, each being a member of the EU, are highly similar. The numbers in brackets represent the respective overall rank of each country. The numbers in small print display the rank a country achieved. Austria, for example, is 6th in patent ranking. Now handing over to Andreas Schütz.
The rankings for data protection are almost in reverse order if compared to ones of the other four categories, as Win already explained. It seems that strict data protection laws are perceived as to lead to higher overall costs for data protection compliance. Countries with lower data protection standards are therefore ranked higher. The Czech system performs almost equally well in each country. Now passing on to Rainer Schulte.
Austria has implemented a reform on its appeal system in IP matters from the beginning of 2014. The Austrian Patent Office lost its boards of appeal, and the Supreme Patent and Trademark Senate was abolished as well. Both are now replaced by the Higher Regional Court of Appeal and Austrian Supreme Court of Justice. The reform also centralizes jurisdiction over the infringement matters at a single institution, the Vienna Commercial Court. As regards the Austrian Supervisory Authority for Data Protection, there was a recent reform as well. Beginning of 2014, the Data Protection Commission got replaced by the new Data Protection Authority, but the competences and powers of the new authority kept the same. Now I'm handing over to Martin again for Hungary, as shown on the slide here.
Hello, Martin Prohaska again, now for Hungary. As you've seen, profit realized in Hungary from the sale of IP rights can be deducted from the corporate income tax, provided the IP right is kept for at least 1 year. Also worth mentioning that the term of protection for sound recordings and performances was extended from 50 to 70 years. Now passing on for Poland to my partner Rainer Schulte.
Hello again. Looking at Poland on the slide here, we can see that the grant of protection for well-known CTMs requires the right holder to demonstrate that the CTM is well-known even in Poland. An injunction which requires the infringer to pay a fixed sum of money is now harder to achieve. This explains the rather poor ranking of Poland. Now I'm handing over to Andreas Schütz for Slovakia.
Slovakia here, in June 2013, the Slovakian parliament passed an extensive amendment to the Act on Copyright and Related Rights. The Slovakian Copyright Act previously was very inflexible, especially with respect to the mandatory requirement of written licensing agreements. The change in Slovakia is a step forward for Creative Commons, shrink wrap, and general public licenses. For the last 2 years, Slovakian courts are now more willing to issue interim injunctions, particularly in patent cases. Now passing back on again to Martin Prohaska.
Martin Prohaska again. On the general note regarding the speed of proceedings in CEE, one of the most important factors is, of course, what the opposing party may do. In most CEE countries, the opposing party will not even be notified of the fact that the claimant applies for an interim injunction. The law does not require that the court issues the injunction within a certain period of time after application. The timing and as to when a preliminary injunction will be issued very much depends on the court and on the judge handling the case. However, in the Czech Republic, there is a 7 days period stipulated by law in which the interim injunction must be rendered. So at least with interim injunctions, the Czech courts rightfully may claim to be the fastest within CEE. So this is now for Austria and CEE. We will now hand over to China to Thomas Patloch.
Thank you very much, Martin. And welcome, everyone. I'm representing the China IP team of Taylor Wessing, and I'm working in a larger team based in Munich, but also in other cities of Germany, as well as in Beijing and Shanghai. Turning to China, the results of the GIPI are somewhat surprising. China in the past GIPIs was consistently ranked at the bottom of the table, and it still remains there in the most recent survey, together with countries like India and Indonesia. So progress in China has somewhat been rewarded by an increase in overall points gained. This is notably so in the area of patents and data protection. But in comparison to its peers, China still scores poorly, in spite of so much IP being created in China these days. The national IP strategy was issued in 2008, and patent filing numbers since then have soared to today 2.4 million applications per year, of which 825,000 applications last year were invention patent applications. As a comparison, in the EPO, the number is much lower, stands around 250, 260,000. China ranks number 1 worldwide in trademark applications, with more than 2 million applications filed in 2013, even when taking into account a single-class publication system, which will be valid until May of this year. Even copyright registration, including software copyright, has strongly increased and now reaches 1 million. The government touts its efforts and focuses strongly on the cultural change inside the country. And for anyone visiting China, this is clearly visible. Counterfeited movies and pirated goods are much less accessible than they used to be, and Chinese companies are pushed by Chinese ministries to achieve indigenous innovation. In spite of all the measures taken, the perception of the respondents to the survey still shows a skeptical view on the IP environment in China, shown here in the table. This view is not shared by Chinese companies, probably, if one looks at the numbers of IP lawsuits initiated by Chinese right holders in the past 3 years. More than 80,000 lawsuits were initiated in 2012 alone, in which more than 9,600 were related to patents. The growth rate of litigation in Chinese courts has been double-digit since the last 2 years in a row, and was more than 46% if you compare the years 2011 and 2012. This strong growth in China for many years now has brought about a strong technological development. While large companies like Baidu or QQ have become household names in Chinese homes, the respondents of the survey may have focused more on the persisting legal uncertainty when it comes to the protection of copyright, trademarks, and software on the Chinese internet. As China is issuing decisions through its courts, in fact, the legal basis for many of these decisions remains vague. Chinese courts and administrative authorities can act very quickly and often are able to provide results within a much shorter time frame than its peers in the EU or in the US. However, lack of sufficient reasoning in important decisions concerning complex patent, trademark, or copyright cases, and a varying degree of quality in decision-making in various parts of the country influence the rating of China. There are efforts to create a unified IP court similar to the examples abroad in Asia, such as Taiwan and Thailand. Still, the very low participation rate of foreigners in litigation in China, which is about 3% of all IP cases litigated, mirrors the lack of trust and confidence in the Chinese enforcement system. Foreigners are more likely to challenge administrative decisions by Patent or Trademark Office than trying to enforce the rights through courts. The costs, as Roland mentioned already, for IP management, especially filing trademarks, and enforcement, continue to soar very strongly, and the shortage of qualified professionals is often lamented. These factors may all have contributed to the lower score in the ranking. On the patent side, the more positive ranking compared to the other areas should have been influenced by strong efforts of the Chinese Patent Office CEE-Poland. The examination time for invention patents is shorter than in Europe, and quality, according to many respondents, acceptable to good. In addition, invalidation procedures, in spite of the split system, often proceed swiftly and can be concluded within a year in first instance. Finally, the large number of patent filings in China may have added to a more positive perception of this part of the Chinese IP system. The Chinese government is offering many incentives to enhance domestic research and development alongside with patent filing. As long as foreign companies are willing to file for patents to be held in China, the preferential tax treatment and subsidies are also available for foreign companies, and almost all subsidiaries of the multinational companies in China have been pushed either by its management or people on the ground to apply for the status for a high new technology enterprise, sometimes with risks for future R&D and patenting policy, as local filing will have to continue to maintain the status. The low scoring of China in terms of trademark protection comes as a surprise. The lack of a faster and more profound revision of the Chinese trademark law compared to Chinese patent law may have influenced the ranking. In addition, companies experience many problems in daily practice when it comes to trademark protection. Bad faith applications are very hard to fight under the current system, even though it is a system based on relative grounds examination. The strong increase in trademark application filings put pressure on the Chinese Trademark Office. Although the office has managed to lower the average grant time from filing to grant to less than a year, the quality of decision-making has noticeably dropped. Evidence requirements, on the other hand, are increased so that even clear-cut free riders cannot be easily removed from the registry. Counterfeiting in China persists at a high level, albeit less visible. The strong increase in trademark-related litigation in Chinese courts shows a tendency for right holders to request more often damage compensation awards. However, on average, compensation granted is very low and amounts often only to a couple of thousand US. This lack of deterrence may have also influenced the scoring. Another issue of importance in the trademark realm is the protection of well-known trademarks. Locally well-known trademarks, including free riding marks of famous foreign brands, thrive in China. The rise of abuse of the title well-known trademark has led to the reform of the trademark law prohibiting advertisement or public reference to being well-known. Still, more than 4,400 trademarks today are recognized as well-known in China by the SAIC alone. The flood of new applications and the need to create space for them may have lowered the scope of protection and allows even infringing trademarks to coexist as long as they manage to survive in the market for a period of time, as can be seen from the famous Lacoste case. This forces companies to take more actions in China, which increases costs in turn, and which may have also influenced the current ranking. A strong improvement in the overall score for copyright protection in China shows the efforts made especially by the Chinese administration and Chinese courts. More than half of all IP lawsuits filed relate to copyright. The academic discussions about the legal problems in the field fit for its purpose are vivid and intense, and may also have been a reason for the delay of the revision of the Chinese copyright law. Like in other jurisdictions, China wants to have a greater change. Software protection, especially through Chinese courts, has improved noticeably. Large-scale companies, often suspicious for infringement, such as Baidu, face more and more lawsuits, both by right holders and copyright alliances. All this heralds further improvement, in particular when it comes to the non-controversial content and commercial goods such as software. The market for so-called cultural goods and a higher level of licensing of copyright-protected works are strongly supported by the Chinese government at all levels. It remains to be seen whether this will be reflected in future GIPIs. With a strong increase by designs year on year for design applications filed in the Chinese Patent Office, the problem of lack of quality applications appears to have strongly impacted the scoring in this field. Design patents are highly useful for combating lookalikes and have been the focus of several high-profile litigation cases, such as the famous Neoplan bus design imitation case. Still, the number of applications filed by foreigners, which should be responsible for a considerable portion of new designs appearing in the Chinese market, is only about 10% of the overall annual application number, and enforcement appears to be expensive and difficult. A challenge under the present system is the lack of possibility to protect partial designs. The search for filed applications, in addition, also requires assistance by professionals and may have to increase the feeling of right holders and designers that there is a lack of transparency. It is interesting to note that China has not been able to rise in the ranking in the two fields of IP protection, which supposedly are somewhat easier to navigate, that is, the trademark and design protection system. In summary, the critical view on China persists. Progress is underway, but may require further examples of high-profile cases won by foreigners in China or decided in favor of Chinese right holders with a strong signal to the Chinese market that the promise of the Supreme People's Court to make IP infringements more costly and to provide more significant rewards for IP infringements to right holders will be followed by actions. We will continue to monitor the development And with this, I'll give back to you, Roland.
Thank you, Martin. So closing off relatively soon, I'm conscious of time, but we will leave time for questions. Right. So the GIPI4 results overall and replies to some of the survey questions have allowed us to identify a number of themes worth mentioning, and they're on this slide here. I referred earlier to the 68% of our respondents that are effectively saying IP laws were not fit for purpose in the modern age, which was largely a complaint about copyright law. However, it does crop up in the context of trademarks and patents, in particular in relation to transshipments and customs seizures. Our modern, more globalized trading habits means any goods now merely passing through EU ports, perhaps going from India to Latin America via Heathrow or Amsterdam. There have been a number of cases where customs have seized the goods on the basis that they infringe a patent or trademark in that country. This is even though there may be clearly no infringement in the country of dispatch or destination. This has triggered WTO complaints and remains an open sore. It's one which the EU Commission has an opportunity to address right now, at least as regards trademarks, with its reforms to the EU trademark system. However, from the draft proposal being debated at the moment, it looks like the Commission may be trying to duck the issue. If so, this will only lead to more uncertainty and will no doubt impact on the exploiting and enforcing GIPI scores going forwards. Each of us have mentioned the impact of costs and cost effectiveness of enforcement, in particular for the various IP rights and regions as we've gone along. Clearly it has an impact on the results, but seemingly slightly less so in GIPI3, which may simply reflect more optimistic economic times than we have now than 2 years ago. Poor cost-effectiveness scores seem not to be fatal, since the US was 25th for cost-effectiveness for patents, and yet 11th overall. Likewise, the top 10 scorers for cost-effectiveness of copyright were among the bottom 12 for copyright overall. We produced the Global IP Index very much with the aim that it will contribute to an informed debate about IP laws, and perhaps encourage greater harmonization and adoption of best practices internationally. Looking at the results in each of the GIPI reports, there has clearly been a tendency towards such harmonization, and this is reflected in the narrow range of scores in most indices and overall. In addition, in the EU, it's resulted in a less of a spread of the member states across each table. This is a welcome trend, although it has to be added that the convergence of scores has not always been towards the higher end, which would seem desirable. It tends to be a convergence towards the middle or just above, although not for designs which have tended towards the lower end. The key future developments that will impact on this have previously been mentioned, but it's worth pulling them together here, and they're on the slide. Adoption of the unitary patent and the UPC in Europe that Paul touched upon. Whatever fine-tuning is coming on the community trademark front, which I spoke about. The bedding down of the US switch to a first-to-file patent system, Paul's mentioned, and it's also possible the adoption of the fashion bill that I touched on. And the adoption by more countries of at least some, and generally more, data privacy laws that Vin has talked about. All this means that we feel sure there will be significant changes ahead, which we will want to look at in future GIPI reports. We hope you find the results we mentioned here, and as expanded in the report, of interest, and welcome your feedback on it. Likewise, please do take part in our surveys that feed into the report, and please encourage others to do so. The questionnaire is permanently open, and there are links to it from our GIPI microsite. We had a stream of questions actually coming in. Various questions are coming in. There was one interesting one on data protection, clearly for you, Vin. Would you like to tackle that?
Absolutely.
Read it out if you wouldn't mind.
I will. This question has come in, and it's really around the low rating in data protection, and the fact that that means strong data protection laws, in which case, why is this regarded as a negative in the table of ratings? And Germany has been cited as a specific example for this question. Now, what we've explored is that there are, where you have a robust legal regime for IP law, that's more favorable for businesses. There's better protection around businesses' IP assets. A more robust data protection legal regime means that there is more of a compliance burden for that business. There is more restriction on the use of data. Therefore, it's harder and less favorable on businesses that rely on personal data processing in that particular regime. And actually, Germany is a very good example of this from the data protection perspective. The law in Germany is higher than the general minimum standard that's set out in the EU data protection directive. The regulatory landscape in Germany is also more complex. We have 16 different regional regulators. We have a federal regulator in Germany as well, so potentially 17 different regulators to contend with. Germany's also been very active on the data protection debate, very critical of data exports, especially to the United States. So the regulators' attitude towards global data flows is a much tougher environment for multinationals with global operations, including operations in Germany. We are going to explore this more carefully, particularly for Germany, on our data protection webinar on the 11th of February. So if Germany is a particular concern to the data protection, please do register for our 11th of February data protection webinar. Right.
Thank you, Vin. There's a short one here for me. Didn't one of your previous reports cover domain names? Why not this time? In fact, GIPI4 did not cover domain names. GIPI2 did. And we dropped it between GIPI2 and 3 simply because there seemed to be very little of major impact going on in the domain name world. No doubt you'll all be aware that there's been something of more significant impact with the introduction of GTLDs, the new ones that have come in, and we think we're probably going to resurrect something on domain names in the next GIPI because of these new GTLDs. These are the ones where you can have .money or .travel or .a brand, which has given rise to some interesting things. We do touch on it in the report a little bit, but in the next GIPI we may well have something in that whole section. There was one, obviously, I think for you, Thomas, which part of the Chinese IP system is most criticized?
Actually, if you look at the IP system here, you will find that trademarks and designs is indeed the daily bread and butter business and still remains a huge issue for the company, simply because you experience it on a daily basis. Supposedly, there's a good administrative system in place which can help you with the raid, but the number of infringements happening and the number of problems you're encountering in a country as big as China makes the whole trademark protection system really a big challenge. And we suspect that in spite of the revision of the trademark law, which has brought about some interesting changes, that this will not be sufficient and that companies will continue to experience more problems in China than in other jurisdictions around the world.
Okay, thank you, Thomas. Shall we have a patent one here? Paul? I like this. This is some diplomatic answer required on this. Will the presence of the in the UPC of judges from different countries make for consistent decisions?
Well, the short answer is yes, but it will take time. There's two reasons for that. Firstly, as I said, or showed in the picture, judges from the various European countries will be spread around the courts, the regional and local courts in the pool of judges, thus communicating with each other and sharing their own interpretations of the law, which incidentally is the same across Europe. It's just interpreted differently in different countries. And the second reason is there is a common court of appeal. So as cases are, over the years, processed through the court of appeal, the Court of Appeal will establish particular approaches to interpretation of the law, and that will feed back down to the more junior courts. But it's going to take time.
I'm conscious of time. I'm afraid we've probably only got time for one more. There's some very interesting ones here. I'm going to be fair for spreading around, one from the CEE team. Do the criminal codes protect copyright in the CEE? Martin or Andreas, perhaps? I think that might be you.
Yeah, here's Andreas. In the Czech Republic, for example, not only natural persons, but legal entities as well can be punished for a breach of copyright, while only natural persons may be punished for the infringement of other IP rights. Another example is the over-enforcement of copyright by the means of criminal law in Slovakia, as the Slovakian criminal code contains a very broadly worded criminal offense as regards an infringement of copyright, which may encompass any willful infringement, no matter how minor it may be. Despite there's a rule saying minor infringement shall not be prosecuted, the level of legal uncertainty is considerably high.
Okay, thank you, Andreas. I think we've come to the end of our allotted time. So firstly, I'd like to thank Paul, Vin, Thomas, Martin, Rainer, and Andres for joining me today. I'd particularly like to thank all of you for listening. Please do look out for further webinars run by Taylor Wessing in the events section of our website. And thank you and goodbye.
Bye-bye.